Hi, my name is Jade Fennick and I'm the head of legal at the Enders Group, and during this video we'll be speaking about areas of intellectual property, more specifically the registration of patents and trademarks. A brand is one of the most important assets that an entity can possess, and therefore it is very important to protect all rights in relation to it. Patentable property must be innovative and susceptible of industrial application. So a patent is a form of intellectual property that gives the creator of an invention the exclusive legal right to market, sell, manufacture and profit from that specific invention. The purpose of a patent is to protect an invention from being used by third parties without the proprietor's authorization. So a patent confers a number of rights to its proprietor. First of all, the proprietor has a right to prevent third parties from making a product or using a process which is the subject matter of the patent. Secondly, a patent also prohibits third parties from offering on the market a product incorporating the subject matter of the patent. An application for a patent shall be accompanied by a request for the grant of a patent, a description of the invention, one or more claims, any drawings referred to in the description of the claims, and an abstract of the invention. So basically the application should disclose the invention in a very clear and coherent manner and must therefore be carried out by a person skilled in the specific area pertaining to such intellectual property. It is possible to change the ownership of a patent or a patent application. The change in ownership will be recorded on the patent register upon payment of a prescribed fee. So it is imperative that the new proprietor is registered, as this is what gives him the right to institute legal proceedings concerning the patent. The term of a patent shall be 20 years from the filing date of the application, and the maintenance of a patent will be subject to the payment of a prescribed fee in respect of the third year and each subsequent year thereafter. Once the patent is successfully granted by the competent authority and has been subsequently published, any person may basically inspect the files of the application. There is a list of property which is exempt from being patented. The list includes discoveries, scientific theories and mathematical methods, aesthetic creations, schemes, rules and methods for performing mental acts, playing games or doing business and programs for computers. One also cannot patent an invention which is considered to be an exploitation contrary to public order or morality. Biological inventions can be patented subject to certain ethical and moral exceptions. For instance, a method for the treatment of the human or animal body by surgery or therapy and the diagnosis method practiced on humans or animals cannot be patented. Yes, a trademark can be registered both in Malta and also at a European Union level. As a first step, we recommend that a pre-application check is carried out prior to starting the registration process. This is done with the national database and the community trademark database to check if there is a similar or identical registered trademark. After the pre-application check is done, the registration itself is conducted. So the application is received by the Commerce Department office, the details are entered into the National Trademark Register, and then a verification check of the content between the database of the original application is made, and then the application is examined on absolute grounds of refusal against national law and relative grounds of refusal with the National Trademark Register and the Community Trademark Register, which means it is performed on both a national level and an EU level. If the application passes through the examination procedure, a notification of registration is issued and sent to the applicant. The registration is then sent for publication on the Government Gazette. So from the day of publication, a 5-year period commences in which any interested party may oppose the registered trademark through the local courts. The procedure for the registration of a community trademark is basically a procedure which comprises of 3 main parts. So first off, there's the examination of the application, and this includes the checking whether or not a filing date may be accorded, formalities examination, and the examination as to the absolute grounds for refusal during which search reports are established. Secondly, the second stage is the publication of the application, and the third part of the procedure up to the registration is basically comprised of any opposition proceedings.